Okay. The next case on my docket is the Jaros matter. Do we have Jessica Jaros, Joshua Jaros, and Mr. Brown? Are you here on this case as well?
I am, Your Honor. Good morning.
Good morning. And there were some parties that indicated earlier that they were present on this case. They asked if they could wait until we started the case to turn on their videos, or at least someone asked me that. But those of you who are here in the Jaros case, if you would activate your videos for me, please. Thank you. Don't mean to invade your privacy. Just try to do this just like we would in open court. And are all of these folks here on the Jaros case?
Yes, Your Honor. Josh Jaros is here.
And Jessica Jaros is here.
Good morning, ma'am.
Good morning.
And let's see. Mr. Champagne, are you here on this case?
I am court watching, Your Honor.
Okay, you're welcome to be.
Can I turn off my video?
Yeah, I don't see why not. Feel
Okay,
free.
thank you.
And Mr. Morgan, are you here on this case as well? Oh, I can't hear you. Let me ask you to unmute just a moment. Okay, very good. Yep, let me put you back on mute for just a second. And then we have someone marked as iPhone. Could you identify yourself for me, sir?
Yes, my name is Rustin Wright.
And are you here on this case?
Yes.
Okay, thank you. I appreciate it. I have two other, besides Mr. Champagne, I have two other squares here at the bottom of my screen. One is indicating Haley Nice. Would you identify yourself, please? Good morning. How are you? Good morning. My apologies, folks. We are still conducting our Zoom docket. I'm not quite sure how long it's going to take, so bear with us. And if you need to step out and do some other business, feel free to do that, okay? All right, thanks. Yep. And I also have a square down here at the bottom of my screen marked as CLOS. Would you identify yourself for the court, please? Okay. So I'm not getting any response. Can y'all hear me okay? I just got a message that my internet connection is unstable. Can everyone hear me okay? Just kind of nod a little bit.
Yes, I can. Yes.
Okay. All right. I'm not getting any response from these two squares at the bottom of my screen, so I'm just going to temporarily put them in the waiting room. They may be here on another case. Okay, so the Jaros matter, anyone who's going to testify this morning or expects to testify, would you please raise your right hands? So I assume that will include the parties, yeah. Do you each solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, very good. So, Mr. Jaros, I think that you are the petitioner in this matter, is that correct?
Yes, Your Honor.
And is it your intent or desire to prove up this modification? Is that correct?
Yes, Your Honor.
I hope I didn't call it a divorce, did I? It's not a divorce, it's a modification case, correct?
Yes, Your Honor.
All right. And so let me get your announcement, Jessica Jaros. Are you intending to go forward to prove this up this morning as well?
Yes.
Okay, and let me hear from the Office of the Attorney General, Mr. Brown.
Good morning, Your Honor. There is a proposed order, but we have not signed it due to some issues concerning the judgment language on the arrears, as well as language regarding the medical and dental support, or the coverage for the medical and dental support.
Okay, all right. Mr. Jaros and Ms. Jaros, the court is happy to approve any agreed matters between parties, provided that they comport with Texas law. And I'm not making any judgment one way or the other, whether your case, whether your proposed court order does or doesn't. But this morning's docket is for the purpose of hearing agreed matters. We have a number of cases this morning. I have a number of people waiting on me in my courtroom as well. And so if we have a matter that's agreed to by all parties, and in your case, the Office of the Attorney General is a party to the case, then we can go forward on it. But if we don't have an agreement by all parties, then we can't go forward until we have that agreement, or until we have a contested hearing, in other words, a trial. So what I'm going to have to do is pass this morning's hearing, give you an opportunity to talk with the Office of the Attorney General and see if some agreement can be reached. If an agreement cannot be reached, then like all cases, the court would urge y'all to go to mediation and see if something can be worked out. And if it can't, then you have a right to have your day in court and to have a trial, and the court is certainly willing to do that.
Your Honor, if I may,
Please.
I had contacted the Attorney General's office last week, and I was told specifically by the Attorney General's office, as well as I'm trying to remember the lady's name right now, in Conroe, and they both said that they do not sign orders like this. I was specifically told that. I asked, and on agreed orders, I was told that they do not sign these particular things, and that there's no signature that goes on these. Now, we could go and do an MSA, which I'm more than happy to go back and do an MSA. This is something that Jessica and I feel very strongly about. We're not taking any state aid. There is no intention to take any state aid. Our children have health insurance. I'm not sure why the AG's office is even involved or objecting to this matter. But look, if we need to, we can go ahead and cancel this. We'll do an MSA if we need to.
Okay. So I don't know what the communications were with the Office of the Attorney General earlier. I'm not disputing what you're saying. I just wasn't a party to those, of course. But I do have Mr. Brown here this morning stating the official position of the Attorney General this morning. And so the court has to accept at least what their position is, just as the court accepts your position. But this is not a commentary or legal advice or anything like that. But you do state something that that I should comment on, which is, it's true that if a mediated settlement agreement is reached, the court generally is supposed to approve the order that's based on that mediated settlement agreement. There's a couple of minor exceptions in the law, but generally, by and large, courts, and this court is more than happy to sign off on any court order that is the subject of a mediated settlement agreement. But I think it's important that you understand that that such a mediation would need to include all parties, unless a party waives their appearance at that mediation. So in other words, the court would need to see the signature of someone from the Office of the Attorney General. For whatever reason, they've been a party in your case in the past, and that means that they're currently a party. Now that may be another legal issue that you wish to challenge. And I'm not commenting on that today either. It's just not the subject of today's hearing.
Okay, Your Honor, I understand where we are. Obviously, tons of constitutional issues right now are rising to the surface of this particular prove-up. I mean, not to mention, just a parent's right to make decisions about their children, but also the 14th Amendment, equal treatment. So I really don't know where we go from here. If we just want to move to an MSA from here, we just thought this would be a lot. We thought this would be a lot easier. I mean, I have an email from the Attorney General's office saying they don't need to be a party on these type of agreements. And I also know that the Texas Supreme Court has ruled that parents, independent of any other party, can make these type of decisions. So I'm not sure if I'm being singled out right now at this moment.
Your Honor, I believe, and I am going to have to interrupt because I believe Mr. Giles is mistaken why we're here. We're not here concerning any issues as to the possession and access or who determines whether children live or any type of agreement like that. We're here specifically because there is language concerning the judgment on the arrears and the release of the arrears that does not comport with law or the way it's supposed to be, as well as the specifics of the who's going to carry the insurance. The order is not specific on who's going to carry the insurance for dental and medical. It recites dental and medical, but it's not specific as to who's going to carry those and the language on the arrears. That is the only reason we're here. We're not here for any of the issues that I believe Mr. Jaros is alluding to concerning who the children stay with or visitation or any of that. No.
And let me just state, Mr. Jaros and Mr. Brown and Ms. Jaros, that the court is overjoyed to hear when parents reach agreements. And the last thing we want is for folks to fight it out in court. We generally think that that's not a good thing for children if it can be avoided. It's inevitable that some cases do end up in court, and that's what we're here for, is to decide those cases. But whenever parties can work things out themselves, trust me, we are all in favor of that. And perhaps you've seen this morning that the court has granted every request that's come before it where the parties have agreed. It's just that in this case, technically, the Attorney General is a party to your case, and that doesn't necessarily mean that the court can't grant relief that you're seeking. It just means that we don't have an agreement today. So I know you both want to get into the substantive issues, or perhaps you don't want to, but you feel a need to. But the court just can't do that this morning. We'll have to take it up another day, okay?
Your Honor, if I could I get at least something from while we're on the record, can I at least get something from the Attorney General's office that says they will communicate with me? Because I've made several phone calls asking questions about what there might be in disagreement. Now, they filed a motion with you here last night. I wasn't even given 3 days notice. I've gotten very little communication with the Attorney General's office.
And Mr. Jaros, I want to make clear that the court would not take up such a motion without proper notice to you. And the court is not taking up that motion, whatever it is. I haven't even seen it today. So I think you are entitled to proper notice. And, Mr. Brown, Mr. Jaros, Ms. Jaros, I definitely encourage all of y'all to talk. Mr. Brown, can you reach out to Mr. Jaros sometime to discuss this?
Yes, Your Honor. Actually, I don't know if we're able to go to a breakout room. I don't know if you would entertain that today, but otherwise he will be contacted. It has been contacted about the issues with the order also. That has been said.
You have Mr.
Yes,
Jaros.
Your Honor.
I think
phone number, Mr.
I think what I'd like
Yes.
to do at this point, Your Honor, if I may, could we just put this all on pause? And I think what I'd like to do is talk to the Attorney General's office. Let's see if we can work it out that way. If we can't, I want to look at my other legal options right now, because it seems, I've been told that this is very unusual to be going through this from several families, attorneys' offices, that this is taking. And I've had people from the Attorney General's office saying that this is highly unusual that this is taking place. No, maybe it isn't, but could you reset us for a prove up? And maybe, I don't know what the schedule is in the next couple weeks, or if it has to be longer, and we can go from there.
Certainly, Mr. Jaros, we're happy to reset it for prove up. And I hope that in the meantime, if y'all can reach an agreement and resolve this, we can rehear this case and discuss it then. You know, you certainly have a right to represent yourself, and I respect that, as do you, Ms. Jaros. I'm not saying anything to the contrary. You know, I would always encourage folks to get legal advice if they can afford it, if they have it accessible. If they don't, there is a legal aid service, and there's even a law library here in Montgomery County staffed by an attorney who is willing to look at folks' documents for free. So sometimes, you know, if the wording isn't perfect, she can take a look at that and help folks get it in order if that's an issue. But we're not even there yet. Just throwing that out there as food for thought, not trying to get in the way of what you want to do.
Sure.
So if you would, I'm going to go ahead and end this hearing for now, but contact our court coordinator, Linda. She's here with us now, but if you'll give her a call after the docket, Mr. Jaros or Ms. Jaros, I'm sure she'd be happy to get you back up on the prove up docket. But just understand that if it's going to be an agreed matter, we would need to see signatures of everyone on that decree. Otherwise, you're entitled to your day in court, and we can set that for you as well. Okay.
Okay. Thank you very much.
Y'all have a great day. Y'all are
Thank
excused.
you, Your Honor.